Seizures versus consensual encounters. So there's two types of police interactions, and they have very different implications for your Fourth Amendment rights. So the Fourth Amendment of the United States Constitution protects you from unlawful searches and seizures, which ensures your personal freedom and privacy. Additionally, in Indiana, we have something separate. It's called Article 1, Section 11. It's very similar to the Fourth Amendment, but it's got some changes. But again, it's Indiana's version of the Fourth Amendment that protects you from unlawful searches and seizures. But what does it mean when you're approached by the police? Well, the first question is this a friendly chat or is it something more serious? And understanding the difference can empower you on whether you need to protect your rights and when to protect your rights when it matters most. So let's start with consensual encounters. This is the least intrusive type of police interaction. In a consensual encounter, an officer, they might approach you and they're just starting a conversation. And the key thing to remember is you're free to leave at any time. These interactions, they can be voluntary. You don't have to answer. You don't have to engage with them. You don't have to show your ID. It's only if you choose to talk to the officer that you need to talk to the officer. So examples of this could be an officer is canvassing an area and they see you and they just ask you, hey, have you heard or seen anything unusual in the area? You don't have to talk to them. A friendly, casual question about a weather or a local event, right? You could be walking down the street, an officer sees you wearing a Pacers jersey and asks you about the Pacers. You're free to leave. You don't have to talk to them. That's your decision. If an officer doesn't give you a reason to feel detained, such as blocking your path or demanding that you answer a question, this is likely going to be what we call a consensual encounter. In a consensual encounter, you always have the right to decline politely and go your way. But the question is, when does a consensual encounter become what we call a seizure? Here's where things can shift. So a seizure occurs when an officer, through force or their authority, restricts your ability to leave or makes you feel like you're not free to go. And this is no longer just going to be a friendly chat. This is something that could be a very serious legal situation. So some clear signs that something is no longer a consensual encounter and has risen to the level of a seizure if an officer is blocking your ability to leave. For instance, an officer stands in front of you or parks their vehicle in a way that prevents you from walking or driving away, right? They're stopping you from leaving. You don't feel like you're free to go. Authoritative commands, statements like stay right here, don't go anywhere, show me your ID. This creates an environment where most reasonable people are going to feel like they are not free to leave. If there's physical contact, something as minor as a firm grip on your arm or an officer putting his arm out, and on your chest and stopping you. These are signs that it's no longer a consensual encounter and it's a seizure. In these situations, the officer's behavior is what's communicating you're not free to go. And that means the encounter has escalated to a seizure. But then again, not all seizures are created equal. The law defines different levels of suspicion required for different types of police actions. One of the most important ones and one of the ones that people know the most about is what we call Terry stops. Terry stops are named after a Supreme Court decision, Terry v. Ohio, where there's brief stops that require just reasonable suspicion. And reasonable suspicion is a specific, articulable reason to believe that you're involved in criminal activity. An example could be an officer sees someone pacing outside of a closed store at 3 a.m., looks like they're nervous, they're looking around. An officer could stop them based on a Terry stop, and they can ask them basic questions, maybe perform a pat down, because they've got reasonable suspicion. But that's a Terry stop. But what happens when we rise to the level of arrest? For a seizure to escalate to an arrest, the officer needs to have probable cause. This is a much higher standard. It requires evidence suggesting that you've committed or are in the process of committing a crime. So if an officer finds stolen goods in someone's possession during the Terry stop, during that pat down, they can place them under arrest. Arrests come with much greater consequences, so the standard of evidence is appropriately going to be much higher. So the question is, how do you protect your rights? This is the million-dollar question. How can you protect yourself during these interactions? The first thing is stay calm and be polite. Even if you believe the officer is overstepping, you want to avoid escalating the situation. Maybe it was a consensual encounter. Maybe it's just going to be a seizure. Hasn't gone to an arrest. Being polite and staying calm can really help you. Ask clarifying questions. If you're unsure about the nature of interaction, you can always ask, am I free to leave? And if the officer says yes, you can leave. If the officer says no, this is now a seizure. Exercise your rights. In a seizure, remember that you always have the right to remain silent and you have the right to an attorney. If it gets to that level, you have those rights. So the line between a consensual encounter and a seizure can sometimes feel very blurry, but understanding the difference, it can be really crucial. So in a consensual encounter, you're free to walk away. In a seizure, the officer must have a legal basis to detain you. Knowing your rights under the Fourth Amendment and separately under Article 1, Section 11 of the Indiana Constitution can ensure that you can navigate these interactions confidently and calmly. If you believe your rights have been violated, or if you have any questions, feel free to give us a call at the Marc Lopez Law Firm at 317-632-3642. And remember, always plead the Fifth.